Thank you so much, Helena.
Well, thank you very much, Mitzi. I hope people can hear me okay. It's great to be back with Thrive at Work. Yes, I'm Helena Morrissey. I'm a legal director at Bevan Brittan. And for those of you that don't know, Bevan Brittan is a full-service commercial law firm. So we offer a wide range of services to businesses. I'm part of the employment, pensions and immigration team at Bevan Brittan, and I'm based in Birmingham. So I'm a very strong advocate of business in Birmingham and the West Midlands. So as Mitzi says, today I'm going to be talking about some of the changes that we anticipate will be coming into force next April, courtesy of the Employment Rights Bill. And then hopefully there'll be some time for a more general Q&A where you can ask me questions about the bill or indeed anything employment law related, and hopefully I'll be able to provide at least some sort of answer for you. Nothing like being on the on the spot, as it were. But yeah, Mitzi, if you want to just move the slide on, if you move 2 slides, if you just move to the next one. As you are aware, the Employment Rights Bill, unless you've been living under a stone for the last 12 months or so, you'll be aware that this bill was proposed last summer. And the aim is to introduce wide changes aimed at essentially resetting the employment law landscape. And this bill will affect various areas of employment law, including family-friendly rights, zero-hour contracts, day one rights, changes to sick pay, changes to the way that trade union recognition and strike action works, and so on and so on. And since last summer, it's been going through the rather laborious parliamentary process that a bill needs to go through to become law. And you'll see from this timeline here that at various stages, there have been various amendments suggested and approved. So it has been a bit of a movable feast as it's gone through the parliamentary process. Most recently, in fact, it was debated at the House of Lords report stage, and the House of Lords actually put forward some amendments which seem to be quite sensible. So, for example, you'll have heard about the day one right for employees to bring unfair dismissal claims. They suggested that there should be a 6-month qualifying period rather than the current 2 years. Changing the proposed right for employers to offer zero-hour workers guaranteed hours, changing that to a right for employees to request guaranteed hours, softening various changes to trade union reforms that are proposed. But unfortunately, the House of Lords amendments have effectively all been rejected by the MPs. So we're back to where we were before it went to the Lords. Now, there is still some uncertainty about what the final version of the bill is going to look like once it receives royal assent. But we have now got a rough sense of where we're going to land, and it is likely to get royal assent next month. And then the changes will start to come in from April. Now, you'll be aware there was actually even some debate when Angela Rayner departed the government whether the bill was going to be paused or even abandoned altogether because of a bit of a wobble in government at that time. There was a lot of noise from businesses, you may be aware, businesses saying that it really should be abandoned or watered down, but equally a lot of noise from trade unions saying that it must proceed full tilt. And it looks like that is going to happen. It does still have very strong government backing. So unless we see a major U-turn, and stranger things have happened, it is going to come into force. Now, as I mentioned, a lot of the changes aren't coming into effect for a year, so we've got a bit of time, and some aren't even coming into force till 2027, but there are some proposed changes which will come into force next April, and it's those that I'm just going to take a very brief canter through today, just to put them on your radar so that you know what's coming down the track next spring. So the first set of changes relates to redundancy consultation, redundancy collective consultation. And you'll be aware that currently, if you don't collectively consult on redundancy properly, you can be exposed to a protective award of up to 90 days pay per employee. Now, from April 2026, this is going to double. So the maximum award an employee can be awarded is 180 days pay per employee. So if you've got a lot of employees bringing a claim, that can be quite expensive. Now, if you consider that earlier this year, as part of its drive to essentially get rid of the practice of firing and rehiring, which also effectively involves redundancy consultation, the government brought in a code of practice, which if employers don't comply with, awards of damages can be uplifted by 25%. So if you combine that 25% uplift with this new 180 days pay, if you are making redundancies in the context of a fire and rehire exercise, protective awards could be up to 225 days pay per employee. So particularly in the context of a fire and rehire exercise, it is very important that you get your collective consultation right. But in any case of redundancy collective consultation, you need to get it right, as the financial penalty for not doing so is going up. And just to put on your radar, looking ahead, you'll be aware that currently collective consultation is triggered where there are 20 or more redundancies at any one establishment. So that's typically any one site or workplace. So even if you've got multi-sites and you're making 3 redundancies here and 5 redundancies here and 10 redundancies here, and the overall number is more than 20, if there are no more than 20 at any one site, collective consultation isn't triggered and you're not exposed to these higher protective awards. That is looking to change, and there will be an element of looking at the overall number of redundancies in the workplace as a whole. So if you have multi-sites and you are making a handful of redundancies in a number of sites, if that number goes over a certain threshold, collective redundancy will be triggered in future. We don't know how that's going to work. That's going to come in by way of secondary legislation. So it could be that a specific number of employees across the business as a whole will trigger collective consultation. It might be a specified percentage of employees. We don't know, but just putting that one on your radar, that is going to come down the track. The government is consulting on the alternative thresholds. They're proposing to go into consultation this winter and early into next year. So if this is of particular interest to you, keep an eye out for that consultation and have your say. The next change is statutory sick pay. Currently, as you'll be aware, this is only payable from day 4 of sickness. Now that is going to change in April, and it will become payable from the first day of sickness. There is also a lower earning limit, so people that earn less than a certain amount, which is currently £123 a week, I believe, they're not entitled to any statutory sick pay. And again, that is going to change. The lower earning limit will be removed and everybody will be entitled to statutory sick pay regardless of how much they earn. Now, those lower earners, they won't get the full rate of statutory sick pay, or they might actually find that they've got a pay increase when they go off sick, which is no incentive to get better. We think it is likely that the amount that lower earners will pay will be 80% of their normal earnings. And the government feels that this sets the right balance between providing lower earners with financial security when they're off sick, but also providing that incentive to go back to work to receive 100% pay when they're better. Now, it's said that there are up to 1.3 million employees who do earn below the lower earnings limit currently. So that is bringing a lot of additional people into scope for statutory sick pay. Although the government has said that it should only cost around £15 per employee to employers. Now, I've no idea how they calculated that figure. I'm not sure I'm persuaded by it. But, you know, the government has said that they want everybody to have financial security from day 1 of sickness, and that they say that employers stand to benefit from increased productivity. That may be the case. My own sneaky personal suspicion is that it will lead to a greater amount of people taking the odd Friday or the odd Monday off going forward, because they know that they're going to get paid for it. But we shall see. We'll see what happens come April. The next set of changes, it's paternity leave and unpaid parental leave. Now, currently, employers who want to take paternity leave or unpaid parental leave need to have a minimum length of service to be entitled to that leave. So it's 26 weeks for paternity leave and a year for unpaid parental leave. Now, these qualifying periods are going to be removed. So these are going to be day 1 rights So employees will be entitled to take these 2 types of family leave from the first day of employment. Now, so this brings it into the sort of line with maternity leave, which is also a day one right. Although it's worth just pointing out that although the right to take such leave will be a day one right, the right to pay, so paid paternity pay, that will still be subject to qualifying service. But it does make this type of leave more accessible to employees who have recently joined a business. There's another change to paternity leave, which is good news for those taking paternity leave. Currently, if a new father wants to take shared parental leave, they will lose their right to any untaken paternity leave once that shared parental leave has been taken. Again, that is changing. So new fathers can now take a period of paternity leave and then a period of shared parental leave, and they will then be allowed to take the remainder of their paternity leave after the shared parental leave. So again, it's just making the provisions for parents, for fathers, more flexible, which I think is, arguably a good thing. Now, this is an interesting one, the Fair Work Agency. This is another change that's being brought in April under the Employment Rights Bill, and it's the introduction of a new enforcement agency, which will essentially bring together existing enforcement powers, which are currently held by various bodies such as HMRC and other enforcement bodies. The government feels that at the moment the enforcement framework within employment law is very fragmented and inefficient. So they're saying that the introduction of the Fair Work Agency will be a strong, recognised single brand for enforcement of workplace rights, and also a place for legal assistance, both for employees and employers. So what will it have responsibility for? Well, it's anticipated that it will have various enforcement powers in respect of national minimum wage, which, as you're aware, is currently sort of regulated by HMRC. It will have enforcement powers in respect of statutory sick pay, statutory holiday, penalties for failing to pay sums ordered by an employment tribunal. It will have regulatory powers in respect of employment agencies and so on. And the intention is that over time, its powers will expand. So it may be that further down the line, it will also have enforcement powers in respect of discrimination, whistleblowing and other areas of employment law. So it's quite a significant change. And as I say, many of these powers are already held by existing enforcement agencies, but the most significant new addition for employers is the enforcement of rights to holiday pay. Now, as you will be aware, holiday pay is notoriously complicated, and many employers do inadvertently get it wrong. So this is now being brought into the enforcement framework, which means that it becomes more incumbent upon employers to make sure they're getting it right, as there's not just the risk of employment tribunal claims, but actually enforcement action from the Fair Work Agency. Now, I think the Fair Work Agency is going to have it's going to have numerous powers, some of which I think are quite draconian. It can issue notices of underpayment. It can enforce failure to comply with obligations such as keeping records, etc. It can issue notices requiring individuals to provide information. It can enter premises to inspect documents. It can seize documents. It can recover its costs from employers. And most notably, in my mind at least, it can bring employment tribunal proceedings on behalf of workers. Now, this is the case even where, potentially, an employee decides that it's not going to take employment tribunal action against its employer, but the Fair Work Agency decides that it's going to in any event. And, this is one change under the bill, one of many changes under the bill, which is going to add to the burden of an already stretched tribunal system. And, it got me thinking, what's the situation if you reach a deal with an employee, perhaps under a settlement agreement, and then that they agree that they're not going to bring a claim? Does that mean that you can nevertheless have to face subsequent legal proceedings in the tribunal that have been brought by the Fair Work Agency? I don't know how it's going to work in practice. I don't think anybody really does until we start seeing enforcement proceedings coming through the system. But it is certainly a significant development in the brave new world of employment law. At this juncture, I just wanted to mention the government fact sheets. The government has published a fact sheet about the Fair Work Agency, which is a good high-level read about this new development. It has actually published a number of fact sheets on all the key developments that are coming in under the bill, which you can easily find on the government website. So, if there are any particular areas that cause you concern or you want to know more about, the government website is a really good place to start. The fact sheets do break the developments down into sort of easy reading, not comfortable reading necessarily, but easy reading. The next changes, there are under the bill various changes proposed in respect to the way trade unions work and strike action. And some of the changes will be coming in April. There are various other changes coming in later next year. But certainly next April, the government intends to simplify requirements for ballot and industrial action notices. So, for example, whilst trade unions currently have to give 14 days notice of industrial action, that will reduce to 10. So employers do still get some notice, but less than they would have had previously, so less time to make plans. The government's also introducing e-balloting, which is likely to increase employee participation in industrial action, because it's a lot easier to send an email or click a button than it is to vote in other ways. And currently, industrial action mandates remain valid for 6 months, and that's going to be extended for 12. So again, that's another area that's of particular significance in businesses that have very active union membership. There's also going to be simplification to the trade union recognition process, which if you've ever been embroiled in on the part of an, on the employer side, it's complicated and you need to be a bit of a mathematician to work your way through it. Just very briefly, at the moment, if a union wants to apply for statutory recognition, they must show that at least 10% of the proposed bargaining unit are union members, and they must show that the majority of them are likely to support recognition. If they can do that, they can apply to the CAC, the Central Arbitration Committee, but the CAC will only order recognition if either at least 50% of the bargaining unit are already members of the union. If not, there will be a ballot, and recognition will only be ordered if the majority of votes that are cast are in favour, obviously, but there is also a requirement that at least 40% of all workers in the bargaining unit actually come out and vote for recognition. So this means that in a ballot, even if the majority or the vast majority of votes are in favour of recognition, if you don't have 40% of people in that bargaining unit actually turning up to vote in favour, it won't get through. So if large numbers don't actually vote, you're unlikely to get recognition. Now, the bill will simplify this process by removing that 40% threshold. And therefore, unions will only need to secure a simple majority in favour to get union recognition approved by the CAC. And this is a case, therefore, I think, where apathy may win the day for unions, because even if only a handful of people can be bothered to turn out and vote, they're likely to get the union recognition. So I think it's important to ensure that if people don't want union recognition, they turn out and have their say in the ballot. Otherwise, as I say, apathy will win the day. There's a small change to picketing, just very briefly, before I come on to whistleblowing. You'll be aware that there's currently a requirement in industrial action to appoint picket supervisors. That's going. And as I said, there are various other changes coming in October in respect of unions and industrial action. Now, whistleblowing protections. Moving on, you'll be aware that there is a whistleblowing regime whereby an employee who reports wrongdoing, breach of health and safety, breach of legislation, breach of law, they'll get protection under the whistleblowing regime. This is being extended so that complaints or reports of sexual harassment will also be treated as protected disclosures. Therefore, employees that bring a complaint or a report of sexual harassment are protected from detriment. And if they're dismissed because of that, that dismissal will be automatically unfair, which gives them greater protection than they currently have under the current sort of victimisation regime. Also, any attempt in an NDA or a settlement agreement to prevent employees from making reports of sexual harassment will be void. In much the same way as now, you can't use a settlement agreement to prevent an employee from blowing the whistle. So again, more strength and protection for employees that are bringing complaints of sexual harassment. And just to flag, I came and spoke to Thrive at Work previously on this in October. The current requirement to take reasonable steps to prevent sexual harassment is expanding, so that employers must take all reasonable steps to prevent sexual harassment. So that's one just to be mindful of. And then I think finally from me, one other step that's coming in April. Well, in fact, I think in 2027, there will be a mandatory requirement for large employers, those of 250 or more employees, to report on their the steps that they're taking in respect of gender equality. So that obviously includes gender pay equality, but it also includes a requirement to report steps that employers are taking to support women going through menopause. But this reporting provision is being introduced on a voluntary basis this coming April. So if you are working on a gender equality report, or you think you might like to, you will be able to voluntarily report on it come April. Again, this is another of the measures that there is a government fact sheet about, if you would like to know more about that particular development. Now, I'll shut up in a second, just to put on your radar. I'm sorry, this is by necessity a very brief canter through, but some of the changes, those are the changes in April. Come next October, so just over a year, some of the changes that we are anticipating coming into force will be a complete ban, other than in exceptional circumstances, on fire and rehire. As I mentioned, a requirement for employers to take all reasonable steps to prevent sexual harassment. Third-party harassment is coming into force, which is a seminar topic in its own right, and the extension of the employment tribunal limitation period from the current 3 months to 6 months, basically meaning employees will have longer to bring a claim before they find themselves out of time, which is likely to lead to more claims. And then in 2027, the day one right for unfair dismissal is likely to come into force. There will be a duty to offer 0-hour workers guaranteed hours. There will be compensation for shifts for 0-hour workers which are cancelled at the last minute or changed or curtailed. There's increased rights for pregnant workers. The new collective consultation thresholds, which I talked about at the start, will come into force, and there will be the introduction of a concept of reasonableness in if you wish to refuse a flexible working request. So a lot coming down the track. As I say, do look at the government fact sheets for more information. Yeah, it is going to be a brave new world. But there's no time like the present to prepare. So you're doing the right thing by being here today.